Good day, dear audience. My name is Shim from Intellectual Discovery. Recently, former CF Chief Judge, former Japanese IP High Court Chief Judge Imura, Germany Federal Patent Court Presiding Judge Voit, Center of International Intellectual Property Study in University of Strasbourg, Director Ribaud, George Washington University Professor Adelman, Professor MeiHsin Wang, Fellow of Royal Society of Chemistry UK, and former President of Licensing Executive International Professor Blacklock, work together to accomplish this book, Law, Politics and Revenue, Extracting on the Intellectual Property, published by Cambridge Scholar Publishing. Today, we are honored to have editors, authors, and experts join me to share highlights in this book. On my left-hand side, Judge Thomas Voit from Germany Federal Patent Court.
Good afternoon.
On my right side, Dr. Jacob Blacklock from Lehman, Lee and Sue.
Good morning.
On my right-hand side, next to Mr. Blacklock, Professor MeiHsin Wang.
Good days, everyone.
Ms. Wang, could you please introduce the book and let us know the highlights of this book?
Thank you, Professor Shim. This book examines numerous pressing issues on intellectual property rights, such as neighboring right, performing arts royalty collection in China, the development of the unified codes and the unified patent system in Europe. Nevertheless, patent litigation and compulsory licensing are also covered. These analyses are complemented by in-depth case studies and demonstration how companies can benefit enormously from an integrated application of all kinds of intellectual property rights, and how industry can profit from patent licensing and acquisition.
Thank you. During April LSI annual conference, Brussels, Judge Voit shared the update of United Patent Court and United Patent System in Europe. We are very honored Judge Voit joined us again today in China. Dear Your Honor, we are aware you personally handled important litigations among Samsung, Google, Apple, Motorola, etc. In China, patent litigation are also drastically increased. Could you, Honor, kindly share your views on intellectual property rights litigation and how we shall resolve patent disputes?
Yes, well, that's right that patent litigations are increasing, but the reason for that is less the wish to solve problems than more the wish to clear the market. And if you see it so, then it is not simple to find a way to resolve this problem.
Thank you very much, Your Honor. Dr. Blacklock is author of China Copyright Law, Neighboring Rights, Enforcement and Collection. Could Dr. Blacklock kindly elaborate on this subject?
Yes, thank you. So everyone is familiar with copyrights, which are the legal rights that an author or developer of an artistic work has in the work. What's less known is neighboring rights, which are the legally protected rights of performers and those who record copyrighted works. And the collection of copyright and neighboring right royalties from China has been very difficult for Western companies and performers due to the difficulty to enforce that with the Chinese legal system. So we have proposed a way to work within the institutions in China, with the Music Copyright Society of China, and develop mutual representation with related societies of the abroad, musical copyright protection societies in the United States or Europe, for example. And through forming agreements between these societies, we can cooperatively work to enforce copyright and neighboring rights royalties in China for foreign artists.
Thank you very much, Dr. Blacklock. It is my understanding that Professor MeiHsin wrote about trend and case analysis on compulsory licensing in Asia. I would like to ask Professor MeiHsin comments on this performing art royalty collection issue.
Thank you, Professor Hsin, again. When people think of compulsory licensing, most of the time, they often think of pharmaceutical only. Indeed, it's a situation almost everywhere in the world. But in my chapter, I mentioned 3 cases in different fields. One is in agriculture insecticide, and it's a Japanese company. The second one is a famous CD-ROM case, and the patent belonged to Philip. But another one is pharmaceutical case, that's Tamiflu patent belonged to Roche, which may have conspired money laundering from government to private company. And I believe it's the situation which terrifies international big company. In reality, both licensing and implementation of patent are very sophisticated profession, and both require various resources and skill. If patent owner could not enforce his or their patent within only 3 years, and then the authority have the right passively or actively to compulsory license to the applicants, is it really fair? I really have the doubt. And World Trade Organization and TRIPS, they allow pharmaceutical product to be exported to the least developing country if compulsory licensing approved based on national health emergency and legitimate causes, but not limited to the pharmaceutical. Domestic market also allow for compulsory licensing if it fulfill the ground in national law and international treaties. Concerning the legitimate compulsory licensing, it certainly comes with the idea of the patent protection. The owner certainly worry about the cross-border control of the goods produced under compulsory licensing, especially for developing country or less developed country, and the re-exportation to the country that could seriously damage the patent owner's profit. Therefore, how to balance the social welfare and respect patent right indeed is a skill of art. And I would suggest that compulsory licensing granting authority should be unified with central control mechanism, not by individual country. And the ground of compulsory licensing should be revised with substantive definition. And the enforcement of the control mechanism and the punishment for violation of the treaty should be regulated. Regarding the avoidance of the pharmaceutical to be re-exported to the place where it should not be, I further suggest the recommended Central Coordination Center is not only responsible for granting and monitoring the compulsory licensing. For pharmaceutical compulsory licensing, the center should be responsible for pooling the needs globally, assign manufacturing site, and monitoring the distribution. The proposed center can also conduct punishment if violation and abuse of compulsory licensing impact the domestic market or global market as intellectual property right, core access for those pharmaceutical companies. And the proposed monitoring system can join the existing ADR monitoring system in pharmaceutical fields, which is a daily adverse event reporting system followed by all country and pharmaceutical company globally. And it's a global record, usually medical adverse events under ICH. And it's the international conference on harmonize of the technical requirement for registration of pharmaceutical for human use. By joining this system, a local pharmaceutical company and doctor, if they receive the complaint from the consumer, and they will report to local FDA depending on the severity of the situation. Local FDA have to report to WTO. Therefore, I think the solution for anti-redistribution should involve the international organizations such as WTO, WHO, and WIPO to work together and make the compulsory licensing monitoring system to join ADR system. And it's the post-marketing surveillance system for medicine to make compulsory licensing with better enforcement and control. Then the merit of the compulsory licensing to serve the poor and the patient less developed country will be flawless.
Thank you very much for our guest today. Our company, Intelligent Discovery, is the oldest IP investment company in Asia. We have noticed the importance of IP in Asia, and we are going to focus on IP transaction in Asia. In that aspect, I believe this book deals with important topic timely. And also, I believe that this book is useful reading for anyone involved or interested in intellectual property law, and will also appeal to those in business world concerned with managing intellectual property and confronting competition with smart strategies. Professor Wang, do you have any more comments or something to add? And what is your next plan?
Thank you again, Professor Shen. Actually, editors and authors, we are currently planning a second book. The proposed title is Law Policy and Monetization on IP. As we are aware, monetization on IP is the current trendy fashion. However, law policy can always ban the situation otherwise. And hopefully, we will be soon back to your program to share our observation and highlights to our new book to your audience. And my sincere appreciation for you to help us to elaborate the highlights to the audience. Thank you very much.
Thank you very much.